Good evening, everyone, and welcome to Renewing Trust in Democracy, the Role of Courts, part of the William W. Treat Lecture Series. The Treat Lecture Series, which is generously supported by a grant from the William W. Treat Foundation, seeks to nurture our civic life and democracy. Judge William W. Treat was a believer in the respectful exchange of ideas across party lines to advance the public good. He was an advocate for human rights, a diplomat, a New Hampshire probate judge, an author, and a banker. He also served as a public delegate to the United Nations General Assembly. He embodied the ideal of civic engagement. The Treat Lecture Series is also supported by a generous grant from New Hampshire Humanities. We are very grateful for New Hampshire Humanities' support of this important civic engagement series. It is so good to see so many of you in person. It's been a while. My name is John Graby, and I direct the Warren B. Rudman Center for Justice, Leadership, and Public Service at the University of New Hampshire Franklin Pierce School of Law. The Rudman Center is very pleased to partner with New Hampshire Civics, which sponsors the Treat Lecture Series, and the Rockefeller Center here at Dartmouth College, which is so graciously hosting us, to co-sponsor tonight's event. Special thanks to New Hampshire Civics Executive Director, Martha Madsen, New Hampshire Civics Program Manager, Amanda Powlick, Rockefeller Center Director, Jason Barabas, Rockefeller Center Assistant Director, Bob Coates, Rockefeller Center Program Officer, Joanne Blay, and Rudman Center Coordinator, Lisa Gilson Clancy, for their considerable efforts in making tonight's event a reality. I am honored now to introduce tonight's speakers. Gregory G. Garr served as the 44th Solicitor General of the United States from 2008 to 2009. He is currently a partner at Latham & Watkins, a private law firm in Washington, D.C., where he is global chair of the firm's Supreme Court and appellate practice. He counsels clients on regulatory, statutory, and constitutional matters and handles an array of complex litigation in the federal and state court systems. He has argued 46 cases before the Supreme Court. A 1987 graduate of Dartmouth, he earned his JD from George Washington University School of Law and served as law clerk to Chief Justice William H. Rehnquist of the U.S. Supreme Court and to Judge Anthony J. Sirica of the U.S. Court of Appeals for the Third Circuit. Neil Katyal is the Paul and Patricia Saunders Professor of Law at Georgetown University and a partner at Hogan Lovells. He previously served as Acting Solicitor General of the United States. He has argued 44 cases before the Supreme Court, and I understand has another one coming up soon. By the age of 51, he had argued more Supreme Court cases than any minority attorney, breaking the record held by Thurgood Marshall. He was a member of the Rockefeller Center's Board of Visitors and was recently elected to the Dartmouth Board of Trustees. A 1991 graduate of Dartmouth, he graduated from Yale Law School and clerked for the Honorable Guido Calabresi on the U.S. Court of Appeals for the Second Circuit and Justice Stephen Breyer on the U.S. Supreme Court. His work has appeared in nearly every leading scholarly law review, as well as numerous op-ed pages. Moderating tonight's discussion is Laura Kanoy, former host of The Exchange, New Hampshire Public Radio's acclaimed call-in news program. As host, first executive producer, and co-founder, Ms. Kanoy shepherded The Exchange into one of New Hampshire's most recognized and respected daily news programs. In addition, Ms. Kanoy has moderated and hosted numerous special events and political debates, is a frequent keynote and commencement speaker, and has received countless national and state awards and accolades. She holds a Bachelor of Arts degree in International Affairs from the George Washington University, where she graduated Phi Beta Kappa, and an honorary doctorate from New England College in recognition of 20 years of bringing critical public policy conversations to the people of New Hampshire. As you entered the hall, you should have been provided with note cards on which to write questions. Please feel free to share your note cards with one of our collectors who will be walking up and down the aisles. You can just wave them down. The collectors will pass the questions on to me, and then I will pass them on to Laura. Now, please join me in extending a warm welcome to Greg Garr, Neil Katyal, and Laura Kanoy.
Thank you, John. Thank you so much, and thank you for inviting me, UNH Law and the Rockefeller Center and New Hampshire Sphinx. It is, as John said, it's great to be here and see all of you, and I hope you can hear me okay through the mask. A little muffled, but the people in the back are giving me a thumbs up, so that's fantastic. And I'm smiling at you, even though you can't, even though you can't see. It's really fun to be here. Just as John said, a reminder, if you do have a question for our guests, I'm going to start with some introductory questions, but please just kind of hold your card up subtly. You don't want to hold it up like this, but hold your card up, and one of our students will come around and collect it. If you are watching at home virtually, you can email your comments to rockyqa@dartmouth.edu. Again, rockyqa@dartmouth.edu. And you can use the word and or the ampersand. We have both. So please feel free to email your questions. It'd be really fun to hear from as many questions from as many of you as possible. And gentlemen, welcome back to New Hampshire. Thank you for bringing in some really nice warm temperatures today. Before we talk about some of the cases before the Supreme Court, I'd like to just ask you broadly what you think about the court's role in these, for lack of a better word, troubled times. I mean, you don't need me to tell you, there's a huge lack of societal trust. People don't trust the political system. They don't trust each other. They don't trust the media. I'd like to hear from both of you on this, but Neil, perhaps to you first. How much do they trust the U.S. Supreme Court?
Okay, so first of all, I just want to thank you all for coming out. It's so nice to be in person, and it's really special to be in this room in particular. It's where I first met Gail, I remember a few years ago, and lovely to be back at this amazing, amazing college. And to do it with Greg, this is going to be an answer to your question, but Greg is just one of the most extraordinary advocates around, and we've done some stuff with Dartmouth together in the past, and it's really a joy to be here with you. And I guess that's part of what I want to start with is I think Greg and I come at this from the tradition of the rule of law, and that there is something different between law and politics. And you can vehemently disagree politically, but still come to the same result legally. And the Supreme Court at its best is that. It's saying, even though, I was appointed by President Nixon to the Supreme Court, I'm going to rule against him unanimously in the executive privilege case, as 3 justices appointed by Nixon did. It's justices recently ruling against President Trump, even though he had put them on the court on the tax returns case. It's Chief Justice Roberts ruling to uphold the Affordable Care Act in 2012 at a time when he had to know if he struck it down, that was kind of all President Obama did for 4 years, and if it was struck down, it would be hard for President Obama to win re-election, but he still voted to uphold it. That, to me, is the Supreme Court at its best. It's the thing we should celebrate. It's the thing that we'll talk about. Does that still exist? Can we expect that in the future?
Do you think Americans trust the Supreme Court, Neil, or do you think they see it as, quote unquote, a bunch of political hacks?
Well, I mean, we're generalizing around 300 million people, so it is
Sure.
the case that, it is the case that, that the trust levels of the Supreme Court have gone down recently quite starkly. There's a new, I think it was a Gallup poll 2 weeks ago that suggested that. The reputation ebbs and flows. I remember after Bush versus Gore, the 2000 case, I think the Supreme Court's legitimacy was also very low. But there are ways to get it back. And, we do have, fortunately, a Chief Justice that really cares and reveres the institution of the Supreme Court and its place in the rule of law. I'll disagree with some of his decisions, sometimes vehemently, but I do think it's what he cares about. And so as the court starts to get into more hot-button stuff, which we'll talk about in the next hour, I think we're all lucky to have this Chief Justice at the helm.
How do you see it, Greg, public trust factor for the U.S. Supreme Court?
Yeah, I see it similarly, and I also want to say thank you so much for having me here, having all of us here. It's a real pleasure to do it with Neil and to do this with you, Laura, and it's always great to be here at Dartmouth. You know, I think these are definitely tricky times for the court. I completely agree with Neil that the court is different, or at least we hold it out to be different, because it's resolving issues of law that shouldn't matter what jersey you're wearing when you go into the robing room or the conference room to make those decisions. And you know, the decisions that teach that, I think, are a good lesson for all of us. And it's also, I think, helpful in very divisive times to see the justices coming together and conversing. I mean, if you walked into an oral argument, and hopefully some of you have seen this, it would, you know, maybe be completely different than what you would expect. You'd see all 9 justices just trying to figure out what the answer to this legal question is, and you know, get to that answer. You wouldn't see anything that you would think would be like, you know, raw politics in play. And then, you know, they hand down these decisions and opine on what the rule of the law is, and it's, you know, really critical for the nation to be able to respect those. The court, you know, is going back to the federal papers, it has neither, you know, purse nor sword. It's sort of up to itself to have its power through the legitimacy and credibility of its decisions, and so that is critical. I do think, though, that this is a really tricky time for the court because the numbers are down in terms of the public trust, which I think, you know, part of that may be the way in which the polling is conducted. But I also think the court is facing an unprecedented backlash from other branches, you know, some of which can date back to the, you know, very controversial confirmation hearings. Part of it, too, is that the justices are much more in the public generally. When I clerked for Chief Justice Rehnquist, he used to like, one of the ways he would get ready for oral argument in the case is he would take his law clerk's hat and we'd go for a walk around the Supreme Court. And, you know, literally tourists would come up to him and say, "Oh, could you take our picture?" You know, not knowing who this person was. He was Chief Justice of the United States. And you couldn't do that today just because, you know, all of the justices are, you know, fairly well known and in the public eye. And I think that has contributed to some of the way in which the court is characterized today.
Oh, well, that's really interesting. And already what they're saying is so interesting. I want to follow up and chuck some of my other questions. So, Greg, you said it's this whole idea of being in the public eye. How has that trust factor changed since you were first arguing before the court? You know, was there some time period 20 years ago or 15 years ago where people said, okay, it's the justices, it's what they say, that's fair?
I think it has changed a lot over our careers and lifetimes. You know, justices are much more well-known as public figures today. They are, you know, in a way, kind of branded during these very public and, you know, more typically these days, controversial confirmation processes. And then they get sort of pigeonholed and they can be portrayed that way. And it's hard for them to break out of that. I mean, Neil and I see, you know, all the time that the way that the Supreme Court operates is completely different than that. I mean, the vast majority, large majority of cases they decide are not decided on, you know, political or, you know, president appointed them lines. It's only the small percentage of cases that actually break down that way. They happen to be very important cases and ones that the nation is rightly interested in. But, you know, as an everyday matter, the court just doesn't function that way.
Yeah, it's interesting. And a little bit later, I will ask our guests what it's like to argue before the Supreme Court, because between them, they've argued 100 cases before the court, which is pretty amazing. But Neil, picking up on what Greg said, you know, he said it's important for people to respect those decisions. Why does it matter if Americans respect or trust the Supreme Court? I mean, it's still the high court. Its decisions, you know, still are the final word. So how much does it matter if people respect their decisions?
Well, I think it's the crown jewel in our kind of constitutional democracy. So if people don't respect it, the decisions may not be enforced. And we already starting to have a little bit of a culture of that, you know, even you know, the last president saying things like, these are so-called judges, they don't know what they're doing, they're not doing my bidding, you know, things like that that are incredibly corrosive to this idea of law being, you know, you just think about Lady Justice blindfolded. I mean, why is she blindfolded? The whole idea is it doesn't matter which party is before her. She'll vote for the one that makes the right argument. And when you start to have politicians or interest groups saying, this is my justice, this is my opposing justice, my enemy, you really corrode that. And it's not the fault of just one president or one political party. It's a real system that's happening. And when people get nominated to the court, I don't think people even these interest groups just come out and just attack or defend without even looking at the record. And, so it's not surprising that the battles in the confirmation hearing room then stick with us the longer term. And, we're going to need the court in all sorts of ways because I do think we're in a society which trust in institutions generally is fraying, trust in each other is fraying. I used to have half of my friends were conservative up until pretty recently, but that started, and as much as I care about it, that's harder to do now. The great thing about the court is at its best, it can point the way to making these bridges and encouraging a healthy dialogue. I know part of what we're talking about here today is not just the court, but civics generally. And the court at its best is a role model for that. When Greg and I go up there and argue, they're not thinking, is this a Republican or a Democrat or who the client is? They're thinking, what's the right answer? And they're asking hard questions of both sides to try and get at that. I am worried, picking up on the question you asked Greg a moment ago, that sometimes actually the justices' own rhetoric to each other is contributing to this decline in the trust of the Supreme Court. I mean, I think it started with Justice Scalia's words, which, he was an incredible writer, but very, very sharp wit, and sometimes, a really hostile wit. I mean, one case he said, I would put a bag over my head before adopting the position of one of his fellow justices. So you've got stuff like that, and it sticks in the public mind more than the boring technical cases that are decided unanimously, which is like a lot of the Supreme Court. I mean, approximately half of what the Supreme Court does is decided unanimously, all 9 of them. But we tend to forget those, and we tend to remember the barbed footnotes.
Wow. Well, and so to both of you, maybe you first, Neil, how much do you think the court has a role in, repairing the breach, so to speak, in our society? What is its role in this incredibly fraught time? And do you think it sees itself as having a role, or is that someone else's problem?
Well, I do think the first job of the court has to be to resolve cases and
Sure.
controversies. So that's the first thing. The way in which they do that, I think, has to be a model for our democracy generally. Listening to both sides, dispassionately, even-handedly, and coming up with a decision. That's one of the reasons I loved arguing before Justice Kennedy, is because it was very clear in a lot of the hard cases, the hot-button cases, he actually hadn't made up his mind before he went in the room. He was truly listening, trying to figure out what the right answer is. So in general, I think that by deciding cases and doing it that way, they accomplish a lot of what they want to do. But for me, I think the court should go further. I think there should be televised hearings. I think it's virtually criminal that everyone in this room, very few of you will get to see a Supreme Court argument in your lifetimes. It's your court. And there's yet only about 200 seats in there for the public on any given day. And I feel like, as we think about modeling democracy and civic engagement, what better thing to see than these justices really asking the hard questions of both sides, listening to their colleagues, and reaching a written, informed decision.
Now, what do you think, Greg? Does the court have a role in repairing the breach?
I think they do. I mean, I think all of us do. I think, as our system of government has become sort of seemingly increasingly dysfunctional and broken, the court as an institution is working, and working much more closely like it was 100 or so years ago, or 200 years ago, than the other branches. It hasn't really changed that much. You still have these 9 individuals doing the work themselves and issuing these decisions. I mean, I think in a broad sense too, you could think of the court as sort of the ultimate guardian of our nation's laws and ideals and principles, and the dialogue that they're having among themselves can be a lesson to all of us in terms of civil discourse, with the caveat that I think Neil's right. I mean, I think that starting with Justice Scalia, who was a brilliant writer, the decisions on the court have gotten a little bit nastier to one another, and sometimes that's really fun to read, but I think ultimately that may not be the best thing for the public's acceptance of the opinions. Having said all that, I think the court has a lot to do to sort of keep its own institution working, and that the onus on some of this should fall on the other political branches as well, because I really do think that we've seen an uptick in the rhetoric on the Supreme Court coming out of Congress and and the presidency as well, that is unprecedented in our lifetime, and that is having a real damaging effect.
What do you think about Neil's idea of televising court hearings, and do you think that they would go for it?
The answer to the second question is no. They won't.
Why is that, Greg? I'm just curious.
I think they feel like they like to do what they're doing without the scrutiny of live television or television. I think there's a great worry that people will splice up the exchanges and make justices as peers. You think, Justice Kavanaugh ought to appear, scary because of this exchange, and not give the full sense of the exchanges that are going on in the court. I think, several of them have been open to cameras in the courtroom, and then they get on the court and they say, no, I'm not supporting it. I mean, I think Justice Kagan's like that. She no longer supports it. Personally, I'm more old school on that than Neil. Neil's on TV a lot more than I am, so I don't mind that there's not televising. But one of the great developments during the last year over the course of the pandemic is that the court is now live streaming its oral arguments, which is a technological leap for the court,
Yes.
but wonderful for all of us.
Yeah, so they don't want to be turned into memes or
Right, exactly.
have 5 seconds of whatever they say clipped up and
Exactly.
misinterpreted. Well, before we move into some of the cases that are actively before the court right now and get our guests' thoughts on those, I want to remind you that we welcome your questions. If you're physically here, hold up your card and one of our students will collect it. If you're watching online, again, you can send in your questions by email. It's rockyqa@dartmouth.edu. Again, rockyqa@dartmouth.edu. So send in your questions by email or hold up your cards, and we'll try to get to many as possible. If you are writing them on the card, write neatly, because I can't read it if it's scrawled all over the place. So, boy, both of you, we could talk for 3 hours about some of the cases before the court now, but I did want to ask you about some of the so-called culture war cases. So, Greg, I'll turn to you first and just ask very broadly, which ones are you watching the most closely?
Yeah, I mean, this term, it really is a blockbuster term in terms of the sorts of cases it has before it. And maybe I'll point to 3, and I'm sure Neil will want to talk about some of these as well. Obviously abortion is back at the court in a really big way, and so all of us will be following that case out of Mississippi closely. The second case that is truly important is testing the scope of the Second Amendment, the individual right to carry a gun. In this case, concealed carry outside of the home for self-defense. It's a case that comes out of New York and challenges New York's licensing regime for concealed carry out of the home. And it's, the court, for the first time in really 200 years, recognized squarely this individual right in the Second Amendment in the Heller decision more than a decade ago, and then hasn't really opined on the scope of that right since, much to the chagrin to some of the more conservative justices in the court that have said that, look, if this were the First Amendment, and it is an amendment, whatever you think of it, we wouldn't just be sort of like ignoring all these cases. So this case, the issue is now back. It appears that the court's going to address it and probably give more guidance on the scope of that individual right, which could have, significant effects on gun laws across the country. And then the last case I'll mention is one involving affirmative action in the education context, which is not on the court's docket now, but the justices have sort of preliminarily expressed an interest in it, asked the United States Solicitor General for his views on it, and we'll make a decision probably in January on whether or not to add that case to the docket this term.
Okay, wow. So guns, abortion, and affirmative action, you're right, that is a blockbuster season.
Yeah.
And I might ask you guys both a little bit more detail on
Yeah.
those cases, but how about you, Neil? What are you watching especially closely?
I think those are the big three, actually. So, so far. But yeah.
What about, let's talk about Roe v. Wade, first of all. Very broadly, this is a huge question. Again, we could spend the whole evening talking about this, but perhaps, Neil, to you first. What would it mean if the justices overturned Roe versus Wade? Again, huge question. If we could break it down, what would be the practical implication of that, Neil, for American women seeking abortions and for the professionals who provide them?
So
What would that mean?
So Roe versus Wade is the 1973 decision, 7-2 decision, written by Justice Blackmun at a time when 7 of the 9 justices were Republican, that upheld a woman's right to choose. And it said that viability was the line at which the state could regulate or not regulate. That's roughly 24 to 25 weeks in a woman's pregnancy. We now have 2 different vehicles to reconsider Roe versus Wade that are pending before the Supreme Court. One is a case out of Mississippi that restricts abortion after the 15th week, directly in conflict with Roe. The second is one out of Texas, which restricts abortion after 6 weeks. And by the way, when I say 6 weeks, I really mean approximately 2 weeks after a woman finds out, earliest time a woman could find out that she's pregnant when her period is missed. So it's an incredibly severe restriction in Texas. Very few women may even know, or if they do know that they're pregnant within that 6 weeks time, they have just a little bit of time to decide. So Mississippi has straight out asked the Supreme Court to overrule Roe versus Wade to justify its law. They even told the Court of Appeals to kind of skip oral argument because they said, look, we know it violates Roe versus Wade. We're trying to challenge Roe versus Wade. So the fact that it violates Roe is, for them a feature, not a bug of the thing. So that case is going to be heard on December 1st. The Texas case is mired in all sorts of procedural stuff that maybe some of you have read about the way in which this law was crafted, a kind of vigilante provision. So the state doesn't actually enforce in Texas their prohibitions against abortion. What they've said instead is that if you aid or abet an abortion in any way, like you're an Uber driver who drives a woman to get an abortion after her 6th week, that you can then be sued by anyone in the state for $10,000, I think, and $10,000 plus attorney's fees and the like. And by doing it that way, they've said, look, the state is not actually involved in the enforcement, so you can't sue the state of Texas the way that the pro-choice groups have tried to do. They said you got to wait until one of these lawsuits is actually brought. And of course, the clinics in Texas can't afford to wait, and they can't afford to take the risk of hundreds of thousands, millions of dollars in liability. So they have restricted abortion procedures accordingly, and to conform with the Texas law. I suspect that the court, they don't want to overrule Roe versus Wade. I think, particularly right before a midterm, strikes me as a hard thing for the court to do. The Mississippi case might allow them to say something that dance around it and say, well, we're not overruling Roe, but we're going to uphold the Mississippi law. I don't think that there's really a straightforward, honest way to do that without overruling Roe, but maybe they'll, come up with some sort of statement to try and paper it over. But the Texas law, it's impossible. No matter how creative you are, you can't really write around that problem. So they may just delay the Texas case and not hear it for a while and only hear the Mississippi case.
So hang on, that's interesting. You said that they probably won't overrule Roe versus Wade right before a midterm. So are they taking into account these political calculations?
I don't know anything on the inside, but I just think that, Roe versus Wade is one of the very few decisions that Americans know by name. And the last time this reached the Supreme Court in such a big way, I was actually a student here, and I remember, thinking about, well, I actually have heard of Roe. I know what that case is. I don't know what any of the other ones are. And the justices in a trio of 3 conservative justices, Justice O'Connor, Souter, and Kennedy, all of whom everyone thought were going to overrule Roe versus Wade, came together and said, this decision is too important. Social expectations have crystallized around the decision. We can't overrule it, basically. It would undermine the legitimacy of the court.
That's
So
interesting.
I do think even if they want to overrule Roe, I think that kind of thinking is going to make it hard. Not impossible, because I think I think that Roe is on very, very thin ice. But I do think it may influence the timing of when Roe is overruled.
I love your thoughts too, Greg, either on the practical impacts, as
Yeah.
Neil described, or on the political impacts.
Yeah. Well, I mean, I agree with Neil in terms of the difference between the Mississippi case and the Texas case. And the Mississippi case, to be clear, is on the court's docket. It's going to be heard in December. It will be decided this year. The Texas case has been up and down the courts in a stay posture. The court hasn't agreed to hear it on the merits, so we don't know even if it will. But I think in the Mississippi case, the court could well decide the case upholding the Mississippi law, which would be a development in the court's abortion jurisprudence and arguably whittle away at the foundation of Roe and Casey, but not actually overrule Roe versus Casey, and that for them to go further and actually overrule it in that case, which the state has very aggressively asked the court to do, would be something to really look at and could have ramifications for the court much more broadly in terms of the institution, the sorts of things we were talking about. Just going back to your first question, because there's some younger students in here, I just want to be clear though that overturning Roe itself wouldn't make any single abortion illegal. What it would do, in effect, is transfer the decisions about abortion laws from the courts to the states in the political process. And undoubtedly that would result in fewer abortion rights for women who lived in states, certain states, like Texas and Mississippi, and that would result in a real restriction, maybe a radical restriction. But much of this debate is about, going back to Roe, where exactly in the Constitution does this right come from? And I think scholars on both sides would tell you that Roe itself wasn't a particularly well-reasoned decision. The question of whether or not to overrule Roe today is a much more complex decision, as Neil rightly pointed out. But the broader question is, this is a decision in which people of good faith are going to disagree profoundly. Is it one that we commit to the courts, or one that the Constitution left to the legislature?
Well, I'm really glad you said that, because I wanted to ask you, Greg. So I've heard other scholars say what you just said, which is Roe isn't based on the most solid legal ground. So if it were overturned, speculation, but still, the threat is there. Would there be another legal case that would put it on more solid footing, or would Congress get involved and put it on, legal footing in terms of having a law on the books?
Right. Well, certainly one possibility is that Congress would then legislate, and then there could well be challenges to that in terms of whether or not this is the sort of law under the Commerce Power, for example, that Congress could actually pass. But I think a Democratic Congress and president clearly would try to pass that kind of law. But certainly one could envision a decision. This is sort of like Casey, where you revisited Roe, and what Casey said is they were leaving the framework of Roe in place, but nevertheless built out on the reasoning of Roe and talked about the importance of societal expectations and the disruptive consequences of overruling one of these decisions that all Americans know by name. I mean, about 10 years or so ago, there was an effort to essentially have the court overturn the Miranda decision, and that by a 7-2 vote, the court refused to do that in a decision written by Justice Rehnquist, very conservative. And one of the things the court that recognized in that case is that everybody knows Miranda. It's part of our popular fabric. For the court to overturn that, could result in undermining the legitimacy of other decisions and the court itself.
Wow.
Just
Go
wanted
ahead.
to jump in for 1 second. I think Greg is right to say that the original Roe versus Wade decision rested on a shaky view of kind of the right to privacy that wasn't executed well in the opinion. But I think over the last 30 years, scholars have really come to understand that the real motive, the real kind of right that's at stake is equal protection. The idea, obviously, a law like Texas is only going to burden half the population. And as a result, in 1992, in the Supreme Court Casey decision, they started to build in the language of equal protection more and move away from privacy. Justice Ginsburg's Madison lecture was all about this and about understanding Roe versus Wade as an equality right, not a privacy right. And that is fully teed up to the court in the Mississippi case as in the Texas case. So you don't need a new case in order to evaluate the equal protection arguments. Those cases provide a vehicle to do so.
Well, I have questions in my hand, and thanks everybody for contributing your questions. You still have time to get some in, so hold them up, and one of our students will come around and collect them, or again, you can send them in by email to rockyqa@dartmouth.edu, rockyqa@dartmouth.edu. And so here's one. Neil commented that he does not always agree with the court. In your view, what have been their biggest recent, last 10 years, mistakes?
Well,
Great question.
there's a list, but I will. I think I have to start with one that is just personal to me, which is the Muslim ban. So, Donald Trump campaigned on an idea. He said on December 7th, 2015, I am calling for a complete and total shutdown of all Muslim immigration to the United States. He later said, quote, Islam hates us, and things like that. And you all will remember what he did that very first weekend in office, signing an executive order that restricted immigration very highly from 7 countries that were overwhelmingly Muslim, between 90.9% and 99.9%. And yes, he changed it. We sued to get that first one struck down. He changed it a little bit the second time. He added the country of Chad, which I think he thought was some guy. But ultimately, it was, to me, just a betrayal of what this country is built on. The idea that our founders had was, you come to its shores, we don't care who you pray to. You obey the law and you pay your taxes and the like, and that's that's part of what the American freedom was. And the idea that we had to have effectively a religious test, I thought was so corrosive to what the American ideal was. And yet, the Supreme Court, in a 5-4 opinion written by the Chief Justice, upheld this as an exercise of the president's national security powers. Now, in the course of doing it, he overruled a decision that I think many of you know by name also, Korematsu. So there was a little bit of good in the opinion. The Korematsu was the case that upheld the internment of Japanese Americans in World War II. But I think the reasoning he used ultimately is Korematsu Part 2. It's basically when the president says national security, then we aren't going to really peer behind that very much. And understand the motivations. And I understand that's true for, I agree that that's generally how the law should work for most presidents. I just think sometimes you have an aberrational one that isn't entitled to the same deference as
I
other
love the
presidents.
question, and I'm going to throw it to Greg too, because it's a really good question.
I would just say the last case I lost. So there. No, I mean, to the broader point, of course, we all, disagree with some of the court's decisions, but I think the important thing is to be able to, read the decision and understand how they got there. And I think if the dialogue is working right, if the court is working right, then you can respect the outcome, even in the cases in which you passionately disagree with it.
I've got a couple questions here about both of your experiences arguing before the court, and these are great. Thank you again, folks, for sending these in. I'll start with you, Greg, on this one. Which justice was your favorite to respond to, and why?
Justice Scalia was wonderful to argue before because he was, very combative. He genuinely, I think, loved the give and take, and liked to be punched as much as he liked to punch, which wasn't to say that I did any punching, but he wasn't someone who was offended for the advocate to try to bring it back, and so it was just a lot of fun to appear before Justice Scalia for sure, and I think even today, to this day, I think his presence at oral argument is missed by all of his colleagues. It's just different.
How about you?
And then I guess I would just say, too, Justice Kagan is, brilliant at oral argument, is, fearsome in terms of the questions that she brings at you. So she's someone who, I would say I fear at oral argument, but she, sort of like a true protege of Justice Scalia in terms of the way she can approach you at oral argument.
Oh, it's really interesting. How
Funny,
about
we
you?
didn't plan this in advance, but my answer would have been exactly the same. For Justice Scalia, who loved to give me a hard time, loved it, but also loved it when I gave it back to him. So, it was always bring it with him. And I remember I argued my first case after he passed away in, I think it was April of 2016, and I just remember walking out and tearing up because it felt like a different profession, honestly, without him on the court. And then I would say Kagan now, but also I would say Justice Alito, and they sit together next to each other, and both of them, there are not that many questions, but the analytic power that each of them has from totally different perspectives is off the charts. And it's the hard question. It's even sometimes a harder question than anything you had prepared for or trained for, and I just remember at one point when I was just Elena Kagan's deputy solicitor general, and at one point we were marveling when she was solicitor general, God, Alito, he's so good with those couple of really sharp questions, and it's so funny for me now to think she's sitting next to him and doing the exact same thing.
Well, this person also asks, and I'll give this to you, Greg, please. Is Chief Justice Roberts' power diluted by having 5 justices to his right?
No question. And if you go back a couple of terms, the Chief Justice had, I think, truly a historic term. Maybe one of the best terms for a Chief Justice since John Marshall. He, as the 5th vote, he was able to decide exactly how the court was going to come out, how far the court should go in a particular case. And if you look at the decisions from that term, including the DACA case where he, sided with the more progressive members of the court, and the Trump decisions and the subpoenas, he had an amazing term for a Chief Justice. Now that's all different. The 5 conservatives can go where they want to go without him. Having said that, as Chief Justice, he does have influence. He has the power of assignment, which means that he could join the majority, assign the opinion to himself, and try to moderate the result maybe. He has the power of reasoning, which is what John Roberts was most well known for before he went on the court as one of probably the most gifted advocate of his generation. And so he has the power of that to influence his colleagues. But it's a much different court today than it was 2 years ago.
Well, and as we talk about the numbers, we've got a couple questions from people who want to talk about these efforts to quote unquote reform the court, and we use that word carefully because reform implies that change is needed, and some people may think that change is not needed. But 2 people ask, and I'd love to hear from both of you on this. Neil, you start, please. Should the court have more members? Pros, cons, and someone else. What are the pros and cons of expanding the court? What is the optimal level? And we've seen this movie before, right? In the 1930s, I think it was. So love your thoughts, both of you, on that. But go ahead, Neil.
So the Constitution doesn't tell us how many justices should serve on the court. So we started with, I think, 5, then we had 6, we had 10 for a while. And these even number ones are very interesting because you can imagine an even decision, evenly split decision too. But we had 10 for a while, but I think starting in 1867, we had 9, and we haven't changed that. And in general, I don't think we should change it without an extraordinary reason, because once you start monkeying with the court, there's really no place for it to end. Let's say that people think it should go to 13 because of some of the gamesmanship that happened, which is undoubtedly true, by by one political party. So let's say it goes to the Democrats wanted to go to 13, and they voted up. Then in 2024 or 2028, Republicans win, and they're upset that the Democrats rushed through 4 new Supreme Court justices, so they go up to 17. And then the Democrats win in like 2032, upset about that. They go to like 47 justices, and then it's like the Supreme Court of India or Switzerland, both of which have about 100 members. And at some point, there's a real danger. On the other side of it, you do have to worry, is the court so out of step with the American public? And are they taking so many decisions away from the people that something has to be done?
Do you feel that the court is out of step with the American public right now?
I think it's somewhat out of step now, the question, but they've so far they've not heard the big cases yet. They're about to start hearing them.
Wow.
And I think that's when, it's one thing if, they're making decisions on smaller stuff that doesn't resonate with the American people. But as they start to move into bigger ones, I mean, it's hard to justify the composition of this Supreme Court, just in terms of where the American public is. I mean, it's just to the right. I mean, John Roberts is a lefty on the Supreme Court compared to his colleagues. That can't be said anywhere else in America, I don't think, very easily. So they're out of step. The question is, do they act on it? And how broadly do they act on it? And if they do, I do really worry about what will happen to the court.
Ideal number. Greg, what do you think?
Well, Neil is absolutely right. I mean, the Constitution doesn't say it has to be 9, so the Congress could change it. But I do think that it's a race to the bottom if Congress does. That 9 is a good number. Once you go up for one political payback, then there's no limit to it. And you've destroyed the court as an institution. Because not only do you have this, constantly jockeying up to get to the right number, but you're telling everybody that the only thing that matters is which political parties puts the justices in place, and that those parties will expect the justices to vote their way. And that would, for the very reasons we were talking about earlier, I think destroy the court as an independent institution of government.
Well, we do have a lot of questions about the politics and the court, and here's another one, and Greg, I'll go to you. Is there any comparison between this court to the Warren Court as ideological mirror image?
That's a great question. I think, if you believed that would tell you that this court, that courts come and go, and that, this court is not as exceptional historically as some might suggest. But having said that, it remains to be seen, number one. And I think the one thing that I would look at in particular is it overturning precedents, and at what pace? Because if you get to that point, then I think you could see more of a sort of mirror image comparison. I also think it's a completely different court in that this court is much more tied to reasoning based on the text of statute, the text of the Constitution, and the Warren Court was more of an era where the type of legal reasoning was completely different, whether or not you agree with the results.
It's a perfect segue into this next question that I'll throw to you, Neil. When you're preparing for oral argument and writing briefs, do you tend to write it from an originalist/textualist perspective, since there's a 6-3 majority?
I think you don't write from any one perspective because the justices have a multiplicity of perspectives. So whenever I'm preparing for an argument, I first want to make sure my brief is speaking to all 9. And that's true, by the way, even in one in which, I know that certain ones are going to be against me or for me. I still want to make the very best argument I can using their methodology. And then I pressure test that in moot courts, in fake oral arguments, in which I'm asking my colleagues to play the view of a textualist or someone who believes in legislative history and not text, like Breyer. So I'm trying to get really, how can I speak to every member of the court, regardless of what methodology they use?
Well, and speaking of how you both argue before the court, Greg, to you first, please. What was the first case you argued before the U.S. Supreme Court, and what was the night before that argument
Yeah.
like?
So it was a case that no one in this room has ever heard of before, probably even Neil. CNL Enterprises versus Citizen Band Potawatomi Indian Tribe. It was a case about the enforceability of a arbitration agreement into which an Indian tribe entered in court. And I lost it 9-0 promptly.
Wow.
And at the time I was working in the Solicitor General's office, and usually for your first case, you either win at 9-0 or lose at 9-0, and I lost mine 9-0. It was absolutely terrifying. You know, it's something, as a lawyer, it's something you dream of doing. And, you know, I had dreamt of doing it. And so to have that opportunity was amazing, but it's also incredibly terrifying. You know, unlike some other things that we do, I mean, you're standing up there all alone, sort of, you know, the nice thing about the Supreme Court is it's a very, you know, majestic, beautiful building with, you know, hundreds of people in there. But at the oral argument, typically, although Neil was just telling me under the new format, this isn't as true, you're very close to the bench. You're about, you know, from here to here in terms of the justices. And so it really feels more intimate and conversational, which is one of the reasons you can actually stand up and complete the oral argument. But the best thing about my first oral argument is that I was able to stand up and sit down in one piece.
Well, I was able, when I was a reporter in D.C., I was able to cover 1 or 2 court hearings, and I felt bad for the lawyer because it's just, there they are, you know. So
My parents would come, they usually would say afterwards, why were they so mean to you? Just doing their job.
how about you, Neil? Your first case and what happened?
So
and how'd
my
you feel the night
first
before?
case was a huge case. It was the constitutionality of Guantanamo. And actually, in a weird quirk of fate, the first time I argued the case in trial court, it was against Greg. Greg was representing the United States government at the Solicitor General's office, and I was representing a guy who was accused of being Osama bin Laden's driver. So when the court agreed to hear the case, it really freaked me out, and I actually tried to give the argument away because I thought I didn't want my inexperience to basically compromise the case. And so I called my friend Ken Starr and said, would you do the case? And he said yes, but then his law firm wouldn't let him. You know, bin Laden's driver is not exactly the, you know, ideal client for many law firms. And then I called another prominent conservative lawyer friend of mine who said, yes, I'd do it, but then he realized he'd signed a brief on the other side. So anyway, I decided to do it, but I was incredibly freaked out. And I took a legal pad out and wrote down the names of all the people who intimidated me the most in the country, not like scary people, but lawyers. And I called them all up and said, will you moot me? Can I practice my argument in front of you? And so I traveled around the country and did that. But for like the month before the argument, every night I would have trouble falling asleep, and I'd wake up with a pit in my stomach and the like. I was arguing against Greg's boss at the time, Paul Clement, who it was his 35th Supreme Court argument, an extraordinary advocate. It was my first, but
That's not a fair fight.
Phenomenal
we
job.
won.
And won.
Oh, what a great story. So what did you learn, Greg, from those early couple arguments that you started to put into practice as you got more seasoned?
Yeah, I mean, the nicest thing about doing it a second time is that you know you've survived through the first time.
Yeah.
And I think, you know, it's really the most simple things, which is, you know, just really to listen to the questions and answer the questions. Oftentimes you're so wrapped up in preparing for oral argument that you've sort of thought through the questions and you've thought through the answer that you've given. So when you start to get that question, you think like, okay, that's the answer. But it's really important to listen. I also think that, and this is one of the hardest things, is that it's effective to give a little bit at oral argument. Typically, you just want to, you know, convince them that you're right, but the best advocates, like Neil and other people, and they can give a little bit. Say, you know, that's a good question. That's the weakest part of our case. Let me tell you why it's wrong. And then, you know, the last thing I would say is just to become a little bit more conversational with the justices, and that's and to invite questions. Questions you're terrified of, but questions are really your friends, because the judge is telling you, or justice, this is what concerns me. Here's your opportunity to tell me why I should still rule for you, and that's exactly what you want. That's the most effective use of
Yeah,
argument.
that's a great technique. How about you?
Well, all of those were brilliant, far better than I could come up with. But the one thing I'd add to Greg's things is that like I first started as really kind of more professor mindset, like I will convince you of X. And over time, I've realized actually as the advocate, you're not the very important, actually. What you are is, you're more of an interlocutor. The justices are talking to themselves at the oral argument. They're not as much asking you questions as they're making points to each other, because they haven't really talked about the case before oral argument. And so if you understand that and understand that the question to you is actually really a point to one of their colleagues, then it's more like you're facilitating a conversation and less like you're actually arguing at the podium.
Really interesting. Wow. Well, we only have time for 2 more questions. So here they are. What is your advice to students and young people growing up and exploring the legal field in such a hyper-partisan era? I love this question. I also want to ask, something similar. What advice would you give people? I'll start with you, Neil. Young people who are thinking about having the career that you all have had, becoming top lawyers and arguing before the U.S. Supreme Court.
Well, this is one reason I wanted to come here and do this, because Dartmouth, unlike many other great schools, doesn't have a law school. And so, it's really important for us lawyers to come and talk to you all, because you don't have the same law faculty to draw on, but you've obviously got incredible faculty who are law trained and know a lot about law, like Bruce and others. But, to me, I think I would hate for someone not to go to law school because they see political partisanship in our society. Indeed, to me, that's the reason to go, because the training in the law is a training in logic and respect for argument and respect for, kind of the strength of institutions and the fabric that, they play in our society, the way in which they weave our society together. And so I do worry that it's harder for people now to go to the Justice Department as a young lawyer if they don't agree with the current president or current attorney general. It really breaks my heart because when I actually, I guess, took over the Solicitor General's office from Greg, and there was a whole conversation in the newspapers about politicized Justice Department under George W. Bush and stuff. And I came in to the office that he had put together over a period of years, and it was thoroughly nonpartisan. Indeed, there were more liberals working in that office. I needed some conservatives, frankly, to hire. And that's the way it should be done. These are non-political positions. The Solicitor General's office, there's only 2 political positions in the entire office. Everyone else is a career, non-political person. And he stewarded that, and I tried to steward that. I'm worried that that stewardship has started to fray.
What advice would you give, Greg, to people who might be considering a similar career to what you and Neil have chosen?
Yeah, no, I agree with all what Neil eloquently said. I mean, I think I would, to the same end, I would say, don't pigeonhole yourself in only communicating with and being with people of like mind. Challenge yourself, talk to people on other sides. I mean, one of the most effective ways to appreciate another side's position is to be put in the position of defending that side's position, as Neil and I often are in cases where we don't get to pick our sides. Usually we client hires us and you have to go in but from that perspective you can sort of see it, and that helps you be a more effective lawyer. And if you're thinking about becoming a lawyer, expose yourself to different views. And then the other thing I would say, just on a more practical matter, is look for opportunities to speak, get up on your feet. When I was, in college and even in law school, it never occurred to me that I would argue a single case before the Supreme Court.
Wow.
So you don't have to, think at this point, I'm going to be a Supreme Court advocate, but it's something that just happened naturally through the progression of a career, and it just starts with, your first brief, your first case, your first argument, and no matter what court.
Last question for both of you. I'll start with you, please, Neil. How can the U.S. Supreme Court and courts in general promote civics education among youth and our adult population? And this person also asks a good follow-up. Why do you suppose courts have in particular taken this on? That's a great question.
Do you want me?
Sure, yeah.
So I think, I do think it's a role for courts, in part just because of the rule of law tradition we started our conversation with an hour ago. So it's a natural place for courts to be. I just don't think that's the only thing. I think it's in part incumbent on legislatures to pass laws making sure that civics is taught at a young age. I think it's really important for all of us, whether law trained or not, to be really celebrating the grand traditions of our founding documents, and they've got all their flaws, of course, but also the amendment process and what happened in Reconstruction and the like. I think all of that is really important. I'm actually doing a TV show for little kids about civics and using animation and songs and things like that. But I think right now, when you see what happened on January 6th, I think this is like so important for people to understand there's far more that brings us together than that divides us. The Constitution is not a partisan document.
Well, I don't want
courts,
to
yeah,
say
civics
anything else. I think
education.
that's a good place to end. 'cause
Yeah,
I couldn't agree
sure.
more.
Okay. Thank you both very much. Wow. Well, and again, thanks to our guests and thanks to everybody for turning out. Again, it's wonderful to see faces. You're not on little square boxes, so that's really nice to see everyone. I'm going to turn it back over to John Graby for some closing remarks, please.
Well, thank you. Thank you, Greg, Neil, and Laura, for a fascinating and incredibly timely conversation tonight. And thanks again to the Rockefeller Center and its wonderful staff for hosting us and making this event possible. If you enjoyed this program, please take a look at the slideshow and take note of the excellent upcoming events that tonight's co-sponsors will be presenting. One of those events, in fact, will be yet another Treat Lecture, which will be taking place on December 2nd and featuring former Defense Secretary General James Mattis. Good night, everyone, and thanks for coming out tonight.